Hey, y'all, hey. Welcome to the Live Love Bugs. It is your host, Queen Blahma said it. And we are back, y'all, for day 124 of the Young Thug YSL RICO trial, you guys. Y'all make sure y'all smack that likety like button on the way in. I think the trial has been going on for a few hours now, but we just gonna go right on ahead and jump into it, okay? I'ma hit play.
Now. I expect Mr. Steele to abide by that. And then what else? Yes, all before the whenever he used it. When did he use it?
2015,
Okay, so
January
yes, he's
2015.
Mr. Steele has.
Huh?
When did he use it?
July 2015, Mr. Sledge.
That's when Mr. Sledge used.
Yeah, that's what I'm asking.
Okay.
So what you use to demonstrate that it's in common parlance needs to all be before that. What else?
255 Bravo is this. Wait, that's the one we just.
That's what we just were looking at, I think.
So 255 Alpha is the same
Okay.
thing apparently.
That's the is that's the one with all of the flyers for we've done that one.
So no, 255 Alpha literally is another 32 pages of tweets.
Oh, 255. Okay, I'm sorry.
Is a PDF, a 32-page PDF
We don't need that, right?
of
The same thing.
the same.
All right,
thing.
Mr. Steele, we don't need 255 Alpha and Bravo, right? Okay.
A couple of pages through there.
With 2 or 3 pages showing that. Okay. All right, what's next?
Is the same ruling in effect with respect to, and I think the court said it's smattering. I don't remember which one that applied to, with the wiping of the nose.
The smattering was the flyers showing his shows.
Okay, so
he's gonna pick 2 or 3 from his exhibit A. I don't know, or wherever they are. 15, whomever it is. I don't know whether you want to use famous people or non-famous people, but the ruling about singing the songs, those are just out. But people using the same kind of hand gestures, pick 3. I don't care what they are. Okay, so what else?
So Mr. Williams, for instance, on Exhibit 34, if it's not already in, it's Defendant Williams himself sitting there wiping his nose, and I think that might already be in. So I'm not sure if that's one that is being offered now. But for the ones that are not already in evidence, is the court's ruling that 2 or 3 other people that are not him who are wiping their nose are what will be allowed?
Wiping their nose, or if it's some other hand sign, just 2 or 3 things, 2 or 3 of these to demonstrate, whoever the other people in the world do this to.
And Your Honor,
I don't know that it's going to establish anything because this is 10 years after we have heard that YSL, which might be or might not be a gang, was created, but
so Your Honor, and we would ask as well, because I've seen, I'm not saying anyone in particular, but we would ask that reference to what is contained in the picture. For instance, do you recognize LeBron James wiping his nose? Not be made until it is established whether the witness on the stand, who is supposed to be the witness through whom it is entered, can establish whether they've seen it, know what it is.
It's not, do you recognize LeBron James wiping his nose? Are you familiar with this? Have you seen this before in your life?
And given that Mr. Steele has already given Mr. Wright the exhibits, the answer will be, yeah, I've seen it.
Well, the fact that I think Mr. Steele probably knows how to handle a witness well enough to lay the foundation properly.
I'm just asking based on,
If
what
you
has
want to
happened
then
so
get up
far.
and ask, never mind, I'm not even gonna suggest that. Okay, so are we clear on that? He can ask before today. What else?
think that the videos of people lip syncing, the wiping of the nose, and the tweets about lying to your mama and telling the truth in court are the only 3 categories.
Okay.
And so since there are so many, I think we've covered
All right,
that. We'll look at it
all right.
closer
And
at
then we've
lunch.
got the proposed exhibit from Mr. Huey. Is there an issue with that? I haven't looked at that yet, but
So we don't object to the whole thing coming in, but I believe Mr. Matthews has indicated he wants to take the the writing off. But if
I don't know what the writing says. And who are these people in this exhibit?
Yes, Your Honor, that would be Chanel drinks.
Okay.
Individuals that.
We may need to come in here. Yes, and
1 second, Your Honor.
talking to your mic. Okay, well, all right.
to be
Hang on,
fair to
let's let them finish whatever and then get back on the same page all at the same time.
Hey y'all, welcome to the chat. We are watching the Young Thug trial. They have muted the trial because they don't want us to hear some information. I'm not talking much. We just watching the trial over here.
Decision. So we can all eat lunch too. And so that your clients can eat lunch. Well, then we're gonna need to come back early. So that's fine. But let's come, I'm gonna give us a half an hour and we'll be back at 1:15. Okay? So that we don't keep the jury waiting any longer than we already have today. Can't you get to there to do that?
Y'all, did they just take a recess? What in the world? I'm not even paying attention. Messaging my kids and stuff.
that ends Summer D ain't right either, boy. And the girl said, you're lying. And Sledge says, man, he told on that boy, man. The person with whom he is speaking says, he said, 2 people wrote a statement on you. She's talking about the detective, I believe. And the girl says, Woody. And Mr. Sledge says, nobody wrote a statement on me. One dude wrote a number. And the girl says, one witness saw you there. He says, he being Mr. Sledge says, it's the number 2 witness, and Woody and Lil D never said nothing about me. They said it about Shannon. That's why they dismissed it. We're not trying to get that part in. The girl says, whoever they came forward October 19th, Sledge says, them folks, he references why it took 9.5 months to come forward, whatever, and the judge, Judge Atkinson, he talks a little about him. We're not getting into that. Mr. Sledge then says the first case got switched, but the body didn't. Basically, he's saying that the judge found no probable cause for him on the murder of Mr. Thomas. The girl references the fact that they've been indicted. They talk about him being able to dismiss it. The young woman asked, what did they say about Shannon and 30 Deep? 30 Deep, meaning Mr. Garlington. Mr. Sledge says, man, 30 Deep brought his name up. Woody brought his name up. I knew YSL Deep. And I put 2 and 2 together. He references something about Shannon's lawyer. And the girl said, someone from YSL said, he said that. I was telling OG, he said either D or DK. He then says, I'm looking for the literal quote, but I'm going to summarize it, the part that is relevant. He says that Lil D's not right. He knows that it's Lil D. They didn't call his name. They called him witness number 2. He knows it's Lil D because that witness told them about all of us meeting up at the condo after, not his words, but he's saying after Donna and Thomas's murder. He told them about all of us meeting there. The only person that could have done that was Lil D. On the stand, while Mr. Sledge is talking, he says, well, the court remembers that he referenced going to Mr. Williams' condo and only seeing Mr. Williams and Bielby, and all that was happening was that they were working on the song Jeffery. Then they left to go to another condo so Mr. Williams could grab some jewelry. And then maybe while he was there, he got a call from Mr. Copeland. Mr. Copeland came over, he can't remember, but he doesn't remember who all was there or what, who all might have been there. But there really wasn't a meeting up there. And on the phone call, the reason that he surmises that it was Quindarius Zachary who told police the information they were able to share at his preliminary hearing is because the details that Quindarius Zachary gave were details that only Quindarius Zachary would have known, because drawing the inference from what he is saying, Quindarius Zachary was there, he was there, the rest of them were there. Nobody else would have known. They were all there but Quindarius Zachary. So him saying, hearing what he heard at his preliminary hearing is what led him to surmise that it was Quindarius Zachary who had told. And Quindarius Zachary had not told him, Antonio Sledge, anything about he just told the police. And then the police trying to protect Quindarius Zachary uses witness number 2. So those links are necessary in order for me to be able to put before the jury the fact that, one, Mr. Sledge and other people that they will later hear about were in fact meeting up. They did meet up at the condo, just like Mr. Sledge said in his factual acknowledgments. And what he is saying on the stand now is wholly different than what he said when he took his plea back in 2022. So it's relevant. I mean, obviously the bar for relevance is low. It's very relevant. It took a few steps to get to why, but that is why I was saying I was laying the foundation for more evidence that was going to come in.
Okay, well, I think that it might be relevant if you can find me like his actual statements where he is saying essentially that had to be little d because he told about us meeting up at the condo, as if, he is saying, I know from my own knowledge being there that this could only have been him because he would be the only other person who knows about it. That part might be relevant because it is inconsistent with what he said on the stand about the only people I knew at the condo were maybe Jeffrey and the people who came with me, which was my baby's mother and my baby. But all of getting it to that,
I don't need all of it. When I said what happened at the prelim, I did not want, and it was an inartful way to elicit that, and I can be more precise. I asked the court for permission so the court knows exactly what I'm talking about to just play that snippet. We have the jail call pulled up, and I believe we have a timestamp as well, that we can play for the court, if the court will allow us to play it for the court.
I'll listen.
And as well, Mr. Sledge denied having any knowledge of any members of YSL speaking to the police. That is something else that he talked about yesterday. That was a question I think that I asked him, not as specific as the stuff that I just said, but.
So tell me, Will.
And also, in this part that the court is going to hear, he says he put it together because that witness that they did not name was buying guns for people within YSL. Quindarius Zachary, we all know, is the one who was straw purchasing for them. And in fact, he was sentenced federally for straw purchasing. He was the one that purchased the gun. I think one of the guns that the witness had in the video that the jury has already seen. And Mr. Sledge in this jail call says he knew it was Quindarius Zachary because they referenced that witness was buying guns for YSL. So we're going to start at 3 minutes
Your Honor.
and 12. We're going to start.
Well,
Before you play it, I'll hear what he has to say,
Thank you,
but
Your
finish what you're saying.
We're going to start the first segment of this jail call from November 19th to 15th. We're going to play is 3 minutes and 12 seconds in, and then we're going to stop it and play other questions, and I'll cede the floor to Mr. Sharp before we start that process.
Okay, and do I have a transcript of these calls somewhere? I do, right? Or no?
no.
Okay, all right, yes, sir.
Respectfully, I'm lost. The putting things together from what was said at a prelim, that was said about my client at a prelim, all of that it's preposterous to me that the state would be attempting to get into any of this. And this seems to be becoming very complicated for something that should be very simple. There's no putting it together. There's no, I realized little D told. There's none of that because I'm going to tell, I'm putting everyone on notice right now. I don't know what Mr. Zachary is going to do, but if there is elicited testimony about my client, stuff about what Mr. Zachary said about my client or to the police or at my client's prelim or at a prelim in general, I am moving for a mistrial. I am of the opinion that the state will have goaded me. I'm putting them on notice. Don't do that. And it's they're trying to backdoor testimony because they don't know if Mr. Zachary is going to testify or not. Now, if it's just a matter, Mr. Sledge, you said you don't remember who was at the condo. Didn't you say to your girlfriend or whatever she was, wife, fiance, that Mr. Zachary was at the condo on the night of January 10th, 2015? Didn't you tell her that on a jail call? And then if he denies it, then we play the little snippet where he says that one thing, then I guess that makes sense. But I don't know why we're getting into, I figured out he was the witness. This is what he said. You know, this is what he said about me. This is what he said about Shannon. He must have known these details. Why are we doing this?
May I respond, Your Honor?
Yeah.
Two things. One, this notion of goading into a mistrial and don't do something is not anything that I can respond to because that is wholly wrong. The fact is, every defendant knows that the state has a good faith basis for putting forth the knowledge that Mr. Sledge had regarding what Mr. Zachary said. Mr. Shart's words to the court seem to suggest that for some reason he believes Mr. Zachary, we won't be able to procure him. He's under subpoena. They know that he is, and we have served him, and we have every intention that he will be here. He's out of the hospital, I'll put it that way. We have the statement that Mr. Zachary has given to the police. We have served it. They know what he said. Mr. Shart is well aware what Mr. Zachary said about his client. The reason that what Mr. Sledge tells his girlfriend is relevant, and the reason that there are those steps that have to be taken, is that Mr. Sledge, as I stated earlier, surmises, he realizes who it is because of the facts that Mr. Zachary shared with police, that police then told about under the label of witness number 2 at the preliminary hearing. Mr. Sledge doesn't say Zachary lied. Mr. Sledge was there. Mr. Sledge has actually said he was there. Mr. Sledge is the one that gave the state, and unfortunately we may have to impeach him on that with other evidence. He's the one that gave us the statement, we met up and Thug gave us money to lay low. All of that aside, I have no words for the whole voting stuff because that's not what we're doing. We would object if Mr. Short even makes
Okay,
one.
let's just get to what it is that he, and I don't know why the part about guns is relevant if you are telling me that he essentially says, I know that's little D because of what he said about us meeting up that only he could have said. That's the part I'd like to hear. And that's the part that might be admissible as a prior inconsistent statement. So let's hear that part.
Right. Move to the part where he said he knew it was little G.
And I guess the guns part, I mean, I guess he did say he never sold. He doesn't know if Zachary's selling anybody guns. So, you know, I guess that could be a second prior inconsistent statement. Yes.
I don't know. I'm not in Mr. Sledge's mind. I don't know his reasons for it, but that was an inartful question from the state because I don't think the truth is that Mr. Zachary has sold guns to different members of alleged members of YSL. I think the allegation is that Mr. Zachary was a straw purchaser. I wouldn't call that selling a gun.
Yeah, so I mean, it may be that if you want to get that in, you need to ask different, more specific questions. But let me hear the part about the meeting up,
Yes, sir.
whatever he says about that.
We're gonna start at 1321. Is it playing? We're starting a little bit before.
About the whole situation, I like really like they told them, they said Noah was there.
Mm-hmm.
You know?
Vera said he went clear, you know what's going on.
Yeah, you know what I'm saying? The whole situation, whoever witness number one is, they thought Noah he say, you remember when we talked on the phone, he's like, well, you didn't know nothing about it, you was in the blind.
Mm-hmm.
They told them folks this. After Lud got killed, all of us met up together and went down over house. Them made that word. That's how you know it's you.
Mm-hmm. So when y'all got that, what Shannon said.
But that, cause they sent me that before Shannon, cause Shannon was still up, so they.
So the old boy's house that we believe he is talking about is Jeffrey Williams' house. That is the only house that he has testified that he went to. We have Mr. Zachary saying they met up at Jeffrey Williams' house. We have other people. It's not like we do not have a good faith basis for knowing and realizing that's who they're talking about, because Mr. Copeland, my apologies.
Why is my client's name coming up in that conversation? There's no inconsistent statement that would lead to admissibility.
Why is that in the courtroom anyway? Is that somebody, what? Is that somebody who has a Rule 22?
Go back up.
So
the second part, Judge, just to orient the court, there is at 5, we wanted to play the part that the court asked about what he said about the witness, but to orient the court as to the question posed just now, we would need to go to 557, where Mr. Sledge references it being Lil D. So if we could
Hang on just a minute, because we got to deal with this one first. So I think it sounds to me like they're saying, here's what happened, and we know X, Y, and Z because we were there. And so I guess the reference to Shannon is because he knows Shannon was there, and he has said on the stand, I didn't know anybody other than Jeffrey and, okay, what?
I think, I don't have a transcript, but what I heard that little snippet to say is little D, and of course we have 2 little Ds. I'm going to assume for the purposes of this statement that he's talking about Mr. Zachary was saying things at the condo and putting Shannon there, meaning, and he also references Nard, who's Demise McMullen, there being the murder scene.
There being the murder scene?
Yes.
Honest to God, a transcript would really help because it's hard to tell what everybody's saying.
our transcript is of the quality. and
Okay, but y'all can retranscribe little snippets. Somebody who knows what the content is, like what is being talked about. It's not, it's not that hard to do.
We have not a formal transcript. We have what is being talked about in timestamp form that we can give to the court.
Okay, so is it your understanding that they're talking about the murder scene or they're talking about the condo right there, what we just heard?
They were talking about the condo when he said that they met up at old boy's house.
All right, if we don't even
We
know
sta-
what's
we-
being said, then
We
I don't
do know
how-
what's
Trial
being
waiting to
said,
happen.
Your Honor. It is
Well,
not a
This
mis-
is a mistrial waiting to happen.
Your Honor, if I may.
Particularly. Go ahead.
Judge, we were playing the clip. We put a portion in about Nard. We're not trying to get in anything about the murder scene or Nard. We are not going to cause a mistrial. We are giving to the court the portions of the call that we wish to play. I'm being specific about the portion because we started the clip a second before where someone was able to pick up Nard and make a whole separate argument about the murder scene does not take away the importance of the portion we're presenting to the court that we need to play, which is that I know it's Lil D because he told the police about us all meeting up at old boy's house after Nut got killed. So nobody is trying to put in anything about the murder scene. Nobody is trying to put in anything about that.
So let me hear the part you actually want to play. Just the part you want to play.
So, Your Honor, is it at this time that we're allowed to play the portion I told you that gave some context to we had a specific part the court just asked us to play that we played. There is a part before that we have said
I don't want the part before it. I want to hear what it exactly and only what you want to play before the jury, because that's what I need to rule.
Yes, Your Honor.
Y'all think this is a mistrial waiting to happen? Happy Friday, y'all. It sounds like the judge even almost agreed on that.
Nobody can hear it. Okay, they're just trying to figure out where to start. Why do we have food in court again? I didn't change that rule. No food in court. Somebody please retrieve the banana and take it back to the back. Well, you can't have food in court either. We're in court right now. We're not on a recess. We're not at lunch. Put it back in your briefcase.
Who the hell is eating? What? Oh, what? This is really a joke. They pulling out bananas and eating and pulling food out of briefcases.
That's fine.
Which,
I don't care about a covered drink. That's fine. It's food.
oh my
Just
God.
number one is this I know it deep. Cause he say, you remember when we talked on the phone, he's like, boy, you ain't know nothing about it. You was in the blind.
Mm-hmm.
They told them folks deep. After Nut got killed, all of us met up together and went down old boy house. Them made that word. That's how you know it's deep.
Okay. If there is an inconsistent statement, this is where we're at, as far as I can tell. Mr. Sledge testified that he couldn't exactly remember who was at the condo. Okay. If there's an inconsistent statement that says D, which is of course complicated because there's two D's, is at the condo that night, then It seems to me it would be easier and cleaner if we just had him
Ask
refresh his recollection.
specifically.
But that's how I know he told. That is, why is that coming
Right,
in?
I'm not sure why that's relevant.
Judge, the reason that that is relevant it's two things I want to respond to. The notion about we don't know which one it is. He makes a distinction in
Let's
the
not worry
call.
about, we don't know which one it is.
Okay, so the reason that it is relevant is because we know, Mr. Sharp knows, everyone knows that what Quindarius Zachary told the police is specific information that will be
Let's
presented.
get to, how about if you ask Mr. Sledge specifically on the stand? You said the only people you remembered were blah, blah. Didn't you tell whoever this is, your girlfriend?
Not me.
You know,
Shit.
did y'all discuss the fact that he was
Leave Blah
also
out.
or something to that effect? And then if he says no, then you confront him with this prior inconsistent statement, which he needs to listen to first without the jury hearing. And then he can say, oh yeah, actually I did. And if he still says, I don't know, then you can play that little part.
Also, Your Honor, we feel it is important that the jury hear what he says, because he said Lil D told on them folks. He told them folks. Earlier in the call, the portion we've not played, there's a distinction. I know I'll get there. The reason that that is important is because he starts out talking about people telling. Yesterday, the court heard him say.
Yes, I don't want to go through all of that again. I can follow the argument, but he does not say told on us.
No, he says,
He
told
says
them folks.
told.
Them folks.
Yeah,
Yeah.
which doesn't mean, I mean, Lord have mercy. We heard Kenneth Copeland say, I told 100 different versions of things. Telling somebody something doesn't mean you're telling on them or you're ratting them out or anything. And I know you, the state, want it to be that, but you don't necessarily get that from, I mean, if you have something that says XYZ told on us, then yeah.
Your Honor, if Miss Hilton and I were the only two people in a room where I ate someone's crackers, and Miss Hilton comes out and she tells my boss, Miss Love ate those crackers. And then my boss announces to the world, Miss Love, you are dismissed because you ate so-and-so's crackers. And I say, well, I know it was Miss Hilton who told, because
yes, that is one version of how something like that could go down. But Miss Hilton could also walk out and say, Miss Love ate those crackers, and there weren't even any crackers in there to begin with, in which case she is not telling on you. So it is an argument, but it is not established just because you think that's what he means when he says that.
Your Honor, I understand the court's position, and I would just say that if the argument has been relevant, the very fact that we're here at the place where there is an argument that the court sees on either side makes it, to me, very apparent.
I said that you can get in the part about what I just, that little snippet you just played, if you confront him with it and he says, yeah, I totally still cannot remember him being there.
And just for the record, Your Honor, the evidence rules do not require that I play it for him before I impeach him with it. So in other words, he does not have to hear it. The rules, I will find it for the court. It's very specific.
Well, if you can recall it to his attention specifically enough without him hearing it, fine. But he has to be confronted with the prior allegedly inconsistent statement and given an opportunity to explain it or deny it or whatever, and then it can come in.
And so telling him what he told her at this time on this call.
But you need to be careful about what you say when you are recalling that to his attention, because we do not need to get into this happened at a preliminary hearing, or you heard it from a police officer who was giving probable cause or anything like that. This is just, he somehow knows that this person has said that, and he's saying, oh yeah, it had to be him because he was there or whatever. Okay.
Your Honor, I want to make sure I stay within what the court is requiring that I do. So, Your Honor, the fact that Mr. Sledge hears a rendition of an account from a witness one that Mr. Sledge recognizes, in his opinion, came from Lil D.
Mhm.
Does not the rendition,
What you claim to be trying to get in is that he said something to his girlfriend that makes it clear that he knew that Lil D was there.
when you say you're talking about Mr. Sledge saying something to me. What I'm trying to get in, Your Honor, is the fact that Mr. Sledge, in telling his girlfriend he knows Lil D was the one that told, knows it because he said he told police that we all met up at old boy's house after Nut was killed. That part, we all met up at old boy's house after Nut was killed, is the part that I'm talking about. And earlier in the call, and we don't even have to, I won't even touch the call before whatever break the court has, if it is not resolved, obviously. But earlier, he is talking about defendant Stillwell, and he is talking about at 5 minutes and
This is the part we haven't gotten to yet.
because
I'm willing to listen to that also. I'm just trying to resolve this one first.
Your Honor.
Yes, Your Honor.
The state began this whole discussion saying that they want to impeach Mr. Sledge with a prior statement because he said that he didn't recall who was there.
So
That's what this whole thing was about. Now we're talking about he told. And I'm going to go back to the same thing because I don't understand what's confusing about this. He was at the whole part about yesterday where Mr. Sledge said, no one told me what they told the police.
Right.
Mr. Sledge was at a prelim.
I know, which is why I'm saying she
agree.
can't get into that part.
But it's not the prelim itself. It's also clear that he got this information from the officer testifying at a prelim.
Right, which is not inconsistent with him saying, nobody talked to me about what they said to the police. I said that yesterday.
Okay, I got you.
I got you too. I mean, I understand what the issues are.
Well,
all right, so let's listen to the second one.
They getting feisty, y'all.
We're starting at 5 minutes and 58 seconds. There's a portion where if we don't clip it out, he's saying that they threw out his charges. We will not play that. We will not get into any of that. We will not get into what did they say about Shannon and 30D. We're not getting into that.
Go to the part you are.
It's about 3 seconds. But
Okay.
we might have to go back. Go ahead. Can we be allowed in Zoom? Here we go.
Because I put two and two together. Because Shannon lawyer.
So get with when he said somebody from YSL they stood that. I mean he said they saved Moon. He said they had another person they saved Moon. He said that, and I was telling the OG. He said either D or DK. I was like, I don't think
it's D. It's D, man, because they said, Shannon got a paid lawyer. So Shannon lawyer like, yeah. So Shannon lawyer like, how could a person that they saying is buying guns from the YSL make a statement on? See, they were trying to hide these names, but he said that, and that's how I noticed.
No.
Okay, we don't have a problem with that.
Okay, so I guess next issue real fast is the portions of the plea presentation that Ms. Love forwarded and Mr. Atkins forwarded this morning.
And there's one more as well.
All right,
Judge.
any issue with the parts that she intends to play? All right, well, she gives a description kind of, I don't know that we, as long as it's just walking through those factual assertions, I don't know that you need, I think you can probably tell from just the description of where she's picking up, what she's talking about, but what's the other portion?
No, not another portion
Oh,
of the video.
Another
Issue.
thing to raise, okay.
Correct. So State's Exhibit 425Y, when we presented them on our, I think, admin day, I believe that the request was made to remove commentary, and there was a phone number on State's Exhibit 425Y that the court said the court did not find relevance, I think, in the post until it became apparent how it was relevant and so forth. Yesterday, when presented with State's 425Y with just the phone number and none of the context, the witness testified, I don't know what that was, but I'd like the court to see the full exhibit with all of it. So the first portion of this post, to make the record clear, this is a post with Mr. Sledge taking a selfie, literally looking up at the camera, holding his apparently recently born child in his arms. The first post by the real Toonk, which the witness has said was his name, says, "I woke up like this." And then the real Toonk tags AK2 Success and says, "My baby." Then the real Toonk says to AK2 Success, "Thank you, sis." And then Katini says, "Such a good father. Keep up the good work, brother," at YSL Toonk.
Okay.
Then the real, you can publish it, I need the record to reflect it. The real Toonk then says, at Kahenti, "Thanks, sis." And then he thanks someone else.
Okay.
After another person congratulates at YSL Toonk, Pizzle Dope says, "Say, Slime, what's your math?" Then the real Toonk says, at Pizzle effing baby, "What the move, Slime?" And Pizzle Dope then says, "Trying to see now, send your number." And then the real Toonk tags Pixel effing baby and gives his phone number.
Okay.
So the context is key.
Okay.
So
Because he said, "I have no idea what any of my
Yes.
phone numbers were," and you need to establish that this phone number is clearly his phone number because he's the one sending it.
yes,
All right, there shouldn't be an issue with that now now he said he doesn't know his phone number. Anybody have an issue with that whole thing coming in? Or you could just try to refresh his recollection with it first.
That's what I was going to
I'll
suggest,
try.
Your Honor.
I'll try again.
Okay. And
I-
then
I
if
know I
that
did. I
still
did.
doesn't work,
And to be clear, we obviously did try to refresh his recollection with the phone number, but we'll see
Right.
if the context
okay.
further
Okay,
refreshed.
that should be fine. All right. Have y'all had a chance to look at the portions of the,
They have the original, but I can
Mhm.
pass it over.
okay. Coming back to the factual assertions, plea colloquy.
I have not. I didn't even realize there was an email sent until
Okay,
just
well.
now. So if I could,
How, far into, how much longer do you think you have with Mr. Sledge?
I expect it to be through probably within no under 2 hours, probably an hour
Okay,
and change.
so by lunchtime.
Yes, yes.
All right, so maybe you'd be doing all of this before we break again, so we need to go ahead and sort it out now. Y'all need what, 5 minutes?
And I can
Okay. All right. Yeah, she hasn't.
Okay. Is the edited version, has the law and crime been taken out? Okay.
So this is just essentially going to be him swearing to tell the truth, identifying himself, and then it's going to be the factual acknowledgments that he says, no, these aren't true. And then the sentencing understandings or whatever that he says, I didn't understand any of that at the time. And then the bottom, that's where he says, I have read and carefully considered all of this, and I've made any changes I want to, and this is all true.
What it has is, in addition to that, so it has the very beginning where he raises his hand and swears to tell the truth.
Right, I said that.
And then from there, I asked him if he understands the charges. It's basically from there, I'm reading and asking whether he understands his charges, the sentence, and the special conditions of his sentence. And then I asked him whether his attorney has explained to him the maximum and minimum for these charges. I stopped right there so as not to put in the maximum and minimum for the charges. Then I pick up at
Your Honor.
Yeah.
While
I mean, it's essentially what you sent and described in the first email of this morning, right?
yes,
Okay.
yes.
in Your Honor, I just want to be clear, to the extent, and you haven't ruled yet, and to the extent that this is allowed in on cross-examination, the state is keeping out the maximum minimums. Gets a little complicated because we need to, through cross, talk about what he has over his head, his bias, his motivation to work with the state.
Okay, well, I don't think he's working with the state from his testimony, but
Well, he,
sure, you
on
can,
December
yeah.
28th of 2022.
yeah,
And at one point, and the state drafted this document, not us,
yeah,
they said the state will be asking for the maximum. So at that point, the maximum, at least for the gun charge, is going to be revealed. I know that sometimes we don't like to say what charges carry that our clients are
Right.
facing, but the state said that they're going to ask for the maximum, and we need to articulate what the maximum is. I just wanted to be
all right,
clear.
that's y'all's choice.
Okay.
Okay. All right, so is there objection to the portions that Ms. Love is proposing to play?
We just have an objection to the extent that we don't feel that they are prior inconsistent
All right.
statements, but we're going to.
All right, well, I'm ruling that they are prior inconsistent statements, so this is in when tendered.
Clear so that there is no confusion for any record later on. The special conditions of his sentence are not portions that were asked about, but they are portions that give context to what he is saying he understands. So when I read the charges, for instance, his current charges, his negotiated sentence, and the special conditions that he shall abide by, all of that, it gives context to to the fact that he said he didn't understand it. So I did not ask him, hey, is this a special condition? Is this a special condition? But I included that in there for context for the rest. So I need to be abundantly clear. What I am saying I am playing is exactly what I have indicated in my email to the court and counsel. And the reasons for it have not changed, but I needed the court to hear that part.
All right, well, I mean, part of what he said yesterday that he didn't understand at the time he signed it was any violation of these provisions or any special condition will result in him being sentenced on count 30, and the DA will recommend serve the maximum. So he's thank you for clarifying the record on that. All right. Okay, are we anything else before we get the jury in an hour after I told them to be here?
And good morning, Your Honor. Good morning, everyone.
Morning.
Your Honor, is the court stop the questioning of the interrogation by Detective Gaither of Mr. Sledge that we objected to when we left yesterday? I didn't understand the relevance, and then
I don't expect her to
Okay.
go back into that.
Thank you.
'Cause I ruled that to be irrelevant.
I don't have an additional part of that I'm trying to get into at this
Okay.
time. And if before I ventured into that, I would bring it to the court's attention, but I don't foresee it at this point.
Okay. All right, let's get the witness in and then we'll get the jury in.
And Your Honor, I believe that Mr. Wright may have apprised the court. He is in Coweta County.
He did not apprise the court of anything. And
Well, he
in
did-
fact, I told him and he assured me that he would be here
There's
through
a good part.
duration.
There's a good part. There's a good part. He has standing
Oh,
counsel.
okay.
That he has. I should have started with
Hello,
that.
you should have.
That he has. I apologize. That he has, and Mr. Sledge has agreed and
Okay.
okayed.
All right. All right. And tell me your name, ma'am. Thank you for being here.
Thank you, Judge.
And I shouldn't say he hasn't apprised the court because he probably apprised one of my staff. I just haven't had anything forwarded to me. So, okay, but as long as Mr. Sledge has somebody here to represent him, that's fine. I would go ahead and get the jury, please. You can come on up and take a seat. Thank you. Good morning, ladies and gentlemen. Thank you for your patience this morning. We started before y'all again, but we weren't able to get through everything. So that's just, how it happens in trials sometimes is we have to deal with issues that require y'all to be patient. So thank you for continuing to be patient. And we're ready to continue now with Mr. Sledge's testimony. Ms. Love, go ahead.
Thank you, Your Honor. And good morning, Mr. Sledge.
Good morning.
Mr. Sledge, yesterday I showed you an exhibit, 425Y, to see if it refreshed your recollection. I'm going to show you what I will label as 425 Yankee Alpha and see if this exhibit refreshes your recollection regarding your phone number back in December of 2014 and in 2015. Okay?
Yes.
May I approach?
You may.
And don't read it out loud, but is the photograph depicted in 425 Yankee Alpha the same photograph that was depicted in the exhibit you saw yesterday?
Yes.
And is that you and your child in that photograph?
Yes.
Do you recall how old your child was in that photograph, approximately?
No, I believe he was just born. I don't.
He was just born?
Yes, I don't exactly know how old he was on that photo.
That's fair. When was that baby born?
Ms. Love, if what you want is the phone number, let's cut to the phone number, okay?
I'm asking for
Let's
another.
get a move on it.
Are you able to read this?
Yes.
Okay. And based on what you are reading,
Try that other mic, maybe. Which I know is also got its own problems, but
do you recall making the posts that you see in the sidelines of this photograph?
They say my name right there, whatever the Instagram name was at that time.
Is this a post that was on your Instagram page?
Yes.
Does this post refresh your memory about what your phone number was?
Yeah, it looked like something I wrote.
Does it look like a fair and accurate copy of what you wrote and posted on your Instagram page?
Yes.
Are you able to now tell the jury what your phone number was?
It say 446628935.
404
Yes.
662
8935.
8935. And
Yeah.
was that your phone number?
I guess I don't remember the look, but I see it on the photo. It said I gave it to somebody, but for my personal knowledge, I don't remember. But from the photo, it's saying it's my number because I sent it to whoever that was.
Your Honor, given that, and thank you, Mr. Sledge. Given that Mr. Sledge does not recall the state tenders State's Exhibit 425 Yankee Alpha as a past recollection recorded.
all right, it's admitted.
Thank you. Your Honor, permission to,
You may.
and Your Honor, there is also the, thank you, Judge. Could you zoom in? All right. Mr. Sledge, would you read the first post that you made?
It said I woke up like this.
And then what's the next one?
My baby.
And are you responding to someone, tagging someone, saying that?
Yeah, I said, it said thank you, sis.
And is that at K2 Success that you're telling that it's your baby?
Yeah, it do. It say thank you, sis.
All right. And what's the next line?
Such a good father. Keep up the good work, bro.
And then who is that person talking?
They said thank you, sis.
Is that person writing to at YSL underscore Tunk?
Yes.
And is that Kahenti, Kahenti, that made that post?
Yes.
In response, do you then tell A at Kahenti, thanks, sis?
Yes.
And then do you tell someone else thank you?
Yes.
Does MDBNELL congratulate at YSL underscore Tunk?
Yes.
After that, does Pizzle.dope ask, say slime, what's your math?
That's a number thing. I don't know. I see the pound sign number for a number
Do
on
you
my
see?
side.
Okay.
If you pay it,
Right here, do you see say slime, what's your math?
oh, okay. I see it on now, but it don't show right here.
You don't see say slime, what's your math?
Okay, right there. Okay.
Okay,
I was looking right there.
that's okay. And then do you respond to at pixel effing baby, what's the move, slime?
Yes.
And then does pixel.dope respond, trying to see now, send your number? They
Yes.
use a hashtag.
Yes.
And then do you respond to at pixel effing baby 404-662-8935?
Yes, but that's yes, go ahead. Yes, I respond to that.
You're able to say whatever
No,
you
go,
need to
go.
explain.
I respond to that.
Okay. And was this post made around the time that your child was born?
Yes.
All right. Now, can you tell us when your child was born?
I just remember December, around December or something.
December, what year?
2014, I want to say.
Thank you. Yesterday, we talked about what happened on January the 10th of 2015. Has any part of what you told the jury yesterday changed regarding what you recall happening January 10th, 2015, after you learned about the murder of Donovan Thomas?
You gotta refresh my memory. I don't remember.
Do you remember what happened after you learned about the murder of Donovan Thomas?
No, could you refresh my memory?
So is it your testimony you do not remember what you told the jury yesterday?
I'm not saying that. I'm just saying I don't remember right now. If you could show me, then I can. I don't remember right now.
Did you testify yesterday that you got a call around 10 something PM, or you got a DM
Yes.
that indicated you and someone else were responsible for the murder of Donovan Thomas?
Yes.
Do you now remember what you did after you got that DM?
No, I don't think I said. I remember saying that I went to Mr. Jeffery's house.
And do you remember what you said or who you said was at Mr. Jeffery's house?
Yeah, whoever. I don't know if he's the cameraman or he just do the videos. I'm not for sure about that.
All right. And is it still your recollection that only Mr. Bean, you, your child's mother, your child are the people that you recall being at that house on 10th Street?
I told you it was other people there, but I don't know the other people.
Did you also testify that none of the defendants in this courtroom were there?
I said, I don't remember seeing none of them. Now, that's what I said.
And thank you for clarifying. You said that yesterday. Is that still your memory today?
If you have anything to refresh my memory, Ms. Love, you can show me and then.
I appreciate that.
But I don't remember.
Okay, so that's still your memory today.
Yeah, that's my memory too. I don't remember.
And what about when you went to Mr. Williams' second residence? Today, do you have any further memory about who all was at that residence?
No, if you have anything that can refresh my memory, you can show it to me, but I don't remember.
And do you not remember any of the defendants in the courtroom here being at that residence?
I don't remember.
Objection asked and answered.
Okay. Do you remember being at Rice Street in November of 2015?
November, yes.
And while you were at Rice Street in November of 2015, do you remember calling and speaking with your child's mother at various times?
I talked to her a lot of times, so you have to refresh my memory.
Would showing you a rough transcript of that call refresh your memory about what was said during, or let me ask you this, do you recall talking to your child's mother on November 19th, 2015 at 8:03 p.m.?
I don't remember the dates, Ms. Love. I talk to her most every day, so I don't remember the exact dates.
Would showing you a rough transcript of a call refresh your memory?
Maybe if you show it to me, yeah.
Right. Your Honor, we will label this states 448 Yankee, and it will not be for the purposes of admitting for the jury, just to refresh his recollection. And Your Honor, yes, I was going to ask if the defense could look at it first.
Yes. There's one more.
Hey y'all, welcome to the Young Thug YSL RICO trial, day 123.
Well, I didn't think it was going to take this long.
Your Honor, Mr. Sledge asked if he could have a moment to read that with his attorney.
All right.
He said he doesn't read as fast as I do.
Okay. Well, if y'all want to go back to the jury room, you can, but I doubt if it's going to be that much longer. And by the time you get back there, I'll be calling you back out again.
Your Honor, may we approach with a member of the defense about a correlated matter?
Sure.
Do I start here?
Yeah.
Trying to be pro.
I think it's because I have this guy. Go ahead.
Trying to be proactive, Your Honor, based on our side of the jury conference earlier this morning regarding that jail call. We went ahead and clipped the portion that the court determined could be relevant and had that sent over to the court and to counsel in the event that it became necessary to play simply that snippet. We sent that so that if there was any disagreement that that was the portion the court acknowledged may be relevant, council could let us know. So we were offering it at this time. I don't know whether the transcript we've provided is going to refresh Mr. Sledge's memory or not. He's having a conversation with his attorney.
I was under the impression that we litigated this morning and that the state, and then you asked the state to play it, and the clip they played was talking about what Shannon's paid lawyer said.
Right, that, I don't think that's this. I think what she has just sent us is that first part we talked about, that is the transcript that he's looking at now.
Okay, I don't know how that could be 28 seconds, but
I mean,
I'll listen.
I don't think it should be 28 seconds either, so I'd like for us to,
Can we play it for the
yeah.
court?
The whole situation, whoever witness number one is, they try to know it's he. How he say, you remember when we talked on the phone, he's like, boy, you ain't know nothing about it. You was in the blind.
Mm-hmm.
They told them folks this. After Lud got killed, all of them met up together and went down old boy house. Them made that work. That's how you know it's deep.
Them folks, after Nut got killed, again, we're backdooring the fact that D said something to the police that's problematic. If Mr. Zachary takes a stand, I will deal with it and I will cross-examine him and it won't be a problem anymore. But I don't want there to be any insinuations, any references, any reference to D telling on people until he takes the stand. And so I don't know why we have to get into what Lil D told them folks to get the fact that he was at a condo.
Do you have the transcript or does you have Mr. Sledge have it?
Mr. Sledge has one copy. I have one.
And if Mr. Sledge needs to hear that outside of the presence of the jury to get context to understand what he said previously, I don't have a problem with that. I just don't want the jury to be hearing Mr. Sledge's phone calls to his girlfriend about what other people told the police. Right.
I think you could accomplish the same thing if you just cut out the witness one because part. I mean, what you're asserting that you want to get in is, I heard that he said these things and we know it's him because of exactly what he's saying. So we don't need the witness one part for that, so.
So we will have Mr. Makins take out witness one.
Because, and just start with he say.
Yes, Your Honor.
And
I don't have the transcript in front of me. I don't have the call memorized, but I did hear
we can play it again.
he's telling them folk what he told them folks.
Yeah,
The whole point of this is just, was Mr. Zachary at the condo that night or not? And I really don't care what the answer is. What I don't want is a bunch of references to what was said at a prelim, and D is telling these folks this and that.
Nobody's gonna know who them folks is from this.
Well, them folks is
Them folks could be anybody.
Your
Them
Honor,
folks could be anybody.
respectfully, Your Honor, them folks in the street is police. That's slang for the police, and I believe the jurors are
Well-
going to be able to put that together.
Well, I don't know whether they will or not, but that's what he said.
I understand that's what he said, but I don't believe that just because he said it, it's admissible. Him talking about what Lil D did, respectfully. If Lil D takes a stand, we'll deal with it.
Okay, well, maybe he'll just remember that Zachary was there after all.
And Your Honor, again, we gave that to him to refresh his memory about who all was there. What I started the questioning with today was, do you have any different?
I
memories?
understand. I was here. All right, I'm gonna hand this back to you. But if he's presented with it, the transcript, and he claims to still have no memory, then I'm gonna permit this in as a prior inconsistent statement. Yes.
This once, but I'm going to say it again. I would suggest someone just play Mr. Sledge's recording and then see if that refreshes his recollection outside the presence of the jury.
I asked him, did he want to, I asked him, do you want me to play it for you? You want to get the transcript? He said, I just like to read it. I just need more time. That's what just happened back there in the presence of his lawyer and chief investigator, Blahma. Anybody want that?
Okay, can
Can you what?
I go talk to the witness and ask if he wants to hear the
I
recording?
appreciate it if the witness would be allowed to talk to his own attorneys.
Oh, I guess only the state gets to talk.
Well, y'all are the ones, you are the one, Mr. Shard, in fairness, that asked for a bench conference
You're right.
and suggested that Mr. Sledge be apprised and that his lawyer be apprised as to maybe what should and shouldn't be said from that transcript. And that is why Ms. Love went out and gave them that transcript.
And Your Honor, I was under the impression that this whole thing about the call had been settled. Apparently, I was wrong about that. But if he needs to listen to the call to refresh his recollection, I don't have a problem. I'm
Well,
just
you
trying
know
to.
what? If he comes in and he says, yeah, that still doesn't help me, but if I could hear myself say it, then maybe that would, then we'll take it from there.
Okay, thank you.
Do we think maybe he's ready, or is somebody gonna let us know, or I mean, his co-counsel could do it. She's still here. That way there's no kind of, one side gets to see Mr. Wright more often than the other side. You can go ahead and take that screen share down for now, since we might not get to that. Yes. 5 more minutes. Anybody else need to use the bathroom? Okay, can you do it quickly? Because I don't want it to turn into another 20-minute recess. We've had about, what, 5 minutes of actual trial time today so far?
There was no objection to the plea video, right?
Hmm?
There was not an objection to the plea video, right?
No one has voiced one. I mean, other than they don't think it's a prior and consistent statement, and I ruled on that. get the jury back. We're ready.
I've instructed him, may I ask his counsel?
You can do it right now while we're waiting on the jury.
Mr. Sledge, have you had enough?
Hang on. We're waiting on a juror.
I'm sorry.
That's why we're all
Y'all
still
were waiting
standing.
on me. I'm so sorry.
All right. Even Ms.
My
Love wants to
apologies.
move the case a little bit now.
I thought they were waiting on me. I'm sorry. I feel a little self-conscious. Mr. Sledge, have you had enough time to speak with your attorney and to review the exhibit label states 448 Yankee that I gave to you to refresh your memory?
Yes,
All right. And is the attorney with whom you reviewed that document the same one that you had on December 28, 2022?
yes,
Were you able to ask questions and gain answers to every question that you had regarding this document?
yes,
All right. Does reviewing States Exhibit 448 Yankee refresh your memory about a phone call that you had with your girlfriend, with your child's mom on November 19, 2015?
yes.
All right. Your Honor, I'm going to place this here as not admitted for the purposes of the record.
All right.
Mr. Sledge, having read States 448, do you have any more memory about who all was at Mr. Williams' condo, or with whom you might have met at the condo after Donovan Thomas was killed?
Could you repeat that, Ms. Love? Repeat it one more time.
Yes, sir. Having refreshed your memory about the phone call that you had with your child's mother,
Yes,
do you have any more memories about who all you met up with after Donovan Thomas was killed?
yes, I think.
All right. When you say you think, who is it that you think you remember you met up with after Donovan Thomas was killed?
Who I met up with, or who I was at the condo. You losing me right now.
Let's go with the way you first said it, or the last said it. Who all was at the condo?
I still don't remember who I was there with. I'm trying to think. I seen the paper, but I didn't see any name really that was on the docket saying who was all there.
Do you remember whether Quindarius Zachary was there?
I think Quindarius Zachary was there when I got there.
Do you remember whether Shannon Stillwell was there?
I still don't remember if Shannon Stillwell was there because I didn't see him personally with my eyes, so I still don't remember if he was there or not.
Do you remember whether Diamante Kendrick was there?
No, I think Mr. Kendrick was not there when I got there.
And when you say you did not see Shannon Stillwell with your eyes, is your testimony today, you know for a fact that you didn't see Shannon Stillwell or that you don't recall?
I don't recall. When I got there, I didn't see Shannon Stillwell there. When I first got there. That's what I'm saying.
At any point, were you, Shannon Stillwell, Diamante Kendrick, Quindarius Zachary, Defendant Williams, in a room at one of his condos the night Donovan Thomas got murdered?
I think we was. I think, yes.
Which one? Which condo?
Not the first one.
The second condo?
Yes.
All right. What were y'all doing?
Nothing. Mr. Williams getting himself together.
At what point did, and let me back up and ask you this. Would you characterize your being there as y'all all meeting up at that house?
I don't think we all arrived at the same time.
That's not what I asked. Would you characterize you all being there as y'all all meeting up at the house?
Yes.
All right. And what purpose did you all meet up at the house for?
They was going to the show and the video shoot with him. From my understanding.
Were you working as head of security for Defendant Williams at that time?
No, I don't think so.
And Kenneth Copeland, was he also one of the persons that met up with you, Shannon Stillwell, Diamante Kendrick, Quindarius Zachary, and Defendant Williams at Defendant Williams' condo?
Yes, he was there.
Okay. He was there and he was one of the ones y'all met up with. Is that what you're saying?
Yeah, he came down to the condo.
All right. Now, what did y'all talk about at the condo when y'all all met up?
I don't basically remember the conversation that we was having, but I don't remember the conversation. I'm gonna say that.
Is it still your testimony that you went to Defendant Williams' condo solely because you got a DM accusing you of Donovan Thomas's murder?
Yes, that's one of the reasons. That's the reason, yes.
Was there any other reason?
I don't remember. If you have anything that can refresh my memory, you can show me, but I don't remember no other reason why.
That's the only reason that you remember today? Okay.
Yes.
Given that that is the only reason you can think of that you went to Defendant Williams' condo, did you talk about the fact that you you were, one, that Donovan Thomas had been murdered, and two, you were one of the ones accused of Donovan Thomas's murder.
Sustained.
Thank you. Did you talk about with the people you met up with the fact that Donovan Thomas had been murdered?
Yes.
All right. Now, about what time did you all meet up at Defendant Williams' second location, his other condo?
I don't remember the time.
Do you recall whether it was before or after midnight?
No, I don't remember.
Based on what you said yesterday, is it safe to say it was definitely after 10 o'clock p.m.?
Yeah, it was after 10 o'clock, if I'm not mistaken.
All right. Do you remember how long you talked about Donovan Thomas's murder with the people that you met up with?
It couldn't have been too long because I ended up dropping Copeland off, so I don't remember how long it exactly was.
What was the atmosphere in the room while you all talked about Donovan Thomas's murder?
What you mean atmosphere? Could you explain that to me?
I can. How did you bring up Donovan Thomas? Well, who brought up Donovan Thomas's murder when you all met up?
I already had spoke about it to Mr. Williams.
Right.
So I don't know who started the conversation at the second location.
Do you remember what the conversation was?
I just know the conversation with me and Kenny Copeland was the one responsible for it.
And was there anything said by anybody else that you remember?
Not really. I just remember Mr. Williams telling me that we ain't have nothing to do with it. Go down now.
Who is the we?
Me and Kenny Copeland.
And do you know how it is that Mr. Williams is able to tell you that you all don't have anything to do with it?
He wasn't directly like trying to tell us what to do. He just was basically saying, don't go to the show and go down there and clear our name.
Okay. Now, to your knowledge, did Kenneth Copeland go to Miami?
I don't know. I think he called me and told me he was in Miami, but I don't personally know, was he in Miami?
And is it your testimony that you didn't go to the show because, well, you wanted to stay and make sure your family was safe?
Yes.
All right. But is it also fair to say that you weren't trying to clear your name? You did not go to the, did you, I'll rephrase. Did you stay back from the show in order to clear your name?
Sustained.
Did you make any efforts to clear your name?
Sustained.
Your Honor, I'm not suggesting the answer. I'm just asking one that's yes or no.
Ask it a different way.
Yes, Your Honor. Did you take Mr. Williams' advice that you say he gave?
Sustained.
What did you do after you were told to not go to the show and clear your name?
I dropped Copeland off and I went on about my business.
Do you make or recall anything else anyone else in that room said about the murder of Donovan Thomas?
Objection asked and answered.
I'm asking if he recalls anything else. He seemed to remember something.
Go ahead.
Do you recall anything else anyone else in that room said about the murder of Donovan Thomas?
No.
After you dropped Mr. Copeland off, did you ever go back to the condo that night?
We talked about this yesterday, Miss Love. I told you I went to the hotel room.
I understand. Did you leave the hotel at any time and go back to the condo?
No.
Did you see either Defendant Williams? We'll start with him. Did you see Defendant Williams anymore before he left for Miami?
You said that night?
Between the time you said you left his condo and the time that he left for Miami, did you see him at any other time?
No,
Did you see Defendant Stillwell at any time after you left Defendant Williams' condo?
no, Ms. Love.
Do you know whether Defendant Stillwell went to Miami?
No, I don't know that neither.
Do you know whether Defendant Kendrick went to Miami?
Well, I think Mr. Kendrick will going because he's supposed to be in the video or something like that, if I'm not mistaken. He was gonna help perform that night.
Do you know whether he went?
I don't know personally because I didn't see it, so I can't say personally that he went.
Do you know whether Mr. Zachary went to Miami?
No,
Did you speak with Mr. Williams at any time that he was purportedly in Miami?
I think he called and checked on me. I'm not for sure. I don't remember that. I think he called and checked on me, but I don't remember.
Did you speak with Kenneth Copeland at any time that he was in Miami?
Well, he told me him, his daughter, and himself or something went down there, if I'm mistaken.
Is that a yes?
Yes, I guess yes.
Did you speak with Defendant Stillwell at any time during a point where he was in Miami?
No,
Did you speak with Defendant Kendrick at any time while he was purportedly in Miami?
no.
Now, when you spoke with these gentlemen that you love that are YSL members, did you always talk with them either in person or on a telephone line, or did you have any other ways that you communicated with them?
We never really talked on the phone that much. Me and Mr. Stillwell probably talked on the phone more than anybody.
And do you count FaceTime as talking on the phone?
Yes,
All right. How often would you say that you FaceTimed with Kenneth Copeland?
not, I can't answer. I don't know.
Did you FaceTime with Kenneth Copeland before he met with you at Defendant Williams' condo?
I don't recall.
Did you FaceTime with Defendant Williams before you went to his condo?
I don't recall. If you have anything to refresh my memory, you can refresh my memory, but I don't recall of talking to Mr. William before I went down to his condo.
What about Defendant Stillwell? Did you FaceTime with him before y'all met up at the condo?
No,
Did you FaceTime with Defendant Kendrick before y'all met up at the condo?
no.
Are you able to give us just a rough estimation of how frequently you spoke with Defendant Williams on FaceTime?
I can't give you that. I don't recall.
Did you, between the time that photograph in 425 Yankee was posted, so around December 2014, and January 10th, 2015, was that the same number that you would have used and FaceTimed with?
I don't know, Ms. Love. I can't answer that question. I don't know. I don't recall that. I don't know.
Okay. Are you able to say with any degree of certainty about how often you FaceTime with Defendant Stillwell, since you said that's who you talk with the most?
We used to FaceTime a lot, so.
And the jury and I don't know what a lot means for you, so could you please tell them what that means?
I can't give you a number of how much we FaceTime. I can't give you that number.
And thank you. I don't need a specific number. Was it every day?
I say yes, probably yes.
Was it multiple times a day or just once a day?
We talked like big brothers, little brothers, so I don't know how many times a day that me and him talked on the phone, but we talked a lot on the phone every day.
defendant Williams and you, how often did y'all talk on FaceTime?
And then Mr. Williams didn't talk on the phone as much as me and Mr. Stillwell did.
All right. Your Honor, at this time, I believe that the instruction that the court has that should precede what will be marked as State's Exhibit 442Y that we have sent would be appropriately read.
All right, so this is going to be about his plea in this case.
Yes.
Okay.
In this case.
All right. So I'm gonna again instruct y'all, and this time everything I'm gonna say is gonna be applicable to this plea in this 2022 case. All right. So you are about to hear, and you actually have heard evidence that this witness, who was a co-defendant in this case, has pled guilty to some of the charges in this indictment. I caution you that the co-defendant's guilty plea conviction itself is only admitted for a limited purpose. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider this co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of the same charges with which the defendant is accused. If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, and they are going to be admissions in this case, this wasn't an Alfred plea, this was a regular guilty plea, you may consider the witness's prior inconsistent statement, that is his guilty plea admissions, including to the allegations and the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have to the issues on trial.
Thank you, Judge. And we are going to play that. I wanted to ask Mr. Sledge a few more questions. Mr. Sledge, yesterday, you, am I correct that you testified that you know of an Antonio Sumlin?
Yeah, I know of him.
Okay. And did you testify that that's the person that you called Obama?
You never asked me, did I call him Obama? Not.
Okay. Did you call him Obama?
Yes.
All right. And how well would you say you know him? You said you know of him. How
Yeah,
well?
I used to see him around, but me and him never really hung out together.
To your knowledge, did he ever claim YSL?
Yes, I heard, yes.
Okay. And when is the last time that you talked with Obama?
I don't know, Ms. Love.
Did you talk with him in 2022?
Yes, probably. Yeah, I probably talked to him in 2022.
Do you know how often? Generally speaking, I don't need a
No,
exact number.
when I seen him, I talked to him.
Okay. Did you ever FaceTime with him?
No, I never been on the phone with him.
All right. Was the last time that you saw him in 2022?
Yeah, in person.
Okay. And do you recall if you ever spoke with him around April 2022?
April 2022?
Yes, sir.
No, I don't recall that.
Do you recall speaking with him around the time that this indictment came out?
I don't remember talking to him when the indictment came out.
Hey y'all, hey. Welcome to the video Love Bugs. Please remember to hit the like button if you haven't already. We are currently watching day 124 of the RICO Young Thug YSL trial. Antonio Sledge is back on the stand.
Did you ever share any bills with Obama?
What bills? What kind of bills?
Any bills. I don't even care what kind. Any kind of bills with Antonio Sumlin.
What you mean by bills? Could you be more
Understand
specific?
what
Could, I'm asking you to be more specific.
money that you owe to somebody else?
No, I don't recall that. I don't recall that.
Did you ever have to pay any rent with Mr. Sumlin in 2022?
Mr. Sumner never paid any rent with me.
Did you ever have to pay any with him?
No.
Do you know of anyone else within YSL who is referred to as Moncton?
No.
Have you ever had any reason to charge money at a door for a light bill?
Now that I know, he never gave me no money for no light bill.
That's not what I asked. Have you, Mr. Sledge, ever had any reason to charge money at a door for a light bill?
No, overruled. Go ahead.
Could you repeat it?
Have you, Mr. Sledge, ever had any reason to charge money at a door for a light bill?
I don't recall. I don't remember, Ms. Love, but I know if you came to my house and stayed for weeks and months, eventually I want some money for you staying there.
I imagine so. Have you ever had any I take it back. Have you ever had any reason to charge money at a door along with Mr. Sumlin for a light bill?
You already asked that question, Ms. Love.
I'm gonna object to relevance at this point.
Your Honor, I have a very good faith basis for asking this question.
Okay, well, you're asking him, basically, has he ever charged money at a door for a light bill? Charged anybody money at a door for a light bill, right? Just maybe ask
Yes.
that and
I,
then,
yes. Yes.
because if he has no recollection, then he has no recollection whether he was with himself or somebody else. So
Yes.
if you want to make sure that he understands the entire universe of people, have you ever charged them? Go ahead and ask that. But then if he doesn't recall, let's move on.
Thank you. Have you ever been upset that people were hanging out with you or at you and a spot you may have shared with Mr. Sumlin and not paid bills?
I didn't share with him. He probably stayed a couple of nights, and when the bill came, I told him to give me money on the bill. That ain't.
Okay. And when you say stayed a couple of nights, where would it have been that he stayed?
He probably stayed in my room because I went home.
Okay. And was that your room on Boulevard or somewhere else?
Somewhere else.
All right. Was it a house that you lived at?
I stayed there when I wanted to.
What street was that house on?
I think it was off Brown Mill. I'm not for sure. I think it was off Brown Mill, though. I'm not for sure.
Did you have a nickname for that house?
No, I didn't have a nickname for no house.
To your knowledge, did anyone ever call that house the Web?
I never hung it. I never been there when they called it the Web.
Do you know of a place called the Web?
I heard of it.
Do you know where it is?
It was off Brown Mill somewhere, but I never been to it. I just knew it was off Brown Mill.
Have you ever seen it?
I didn't know exactly what house it was whenever they was calling the Web, but I never been to it at that time, so I don't know.
Who is the they that you're referring to that called it the Web?
The streets. I heard people like at the gas station, like, I'm about to go to the Web. So I don't know.
Were those people YSL?
I guess.
Did you ever hear anybody other than YSL members talk about going to the Web?
Yes, I don't hear females say they was going to the Web.
All right. Do you know or have any idea how far the web was from the place you said that you were at off Browns Mill Road?
No, I don't know exactly.
Do you know the last time that you talked to Kenneth Copeland?
I can't tell you the last time I talked to Kenny Cole.
Do you recall whether you talked to him in 2022?
I don't recall.
Do you remember talking to Kenneth Copeland at all while Kenneth Copeland was in prison around that time? That time being 2022.
I don't know if I talked to Kenny Copeland in that time. I'm not for sure, my lord. I don't want to say the wrong thing, so I'm not for sure.
Right today, you don't remember?
Yeah, I don't remember. Right.
Okay.
So.
Do you remember whether you talked to Demekion Garlington?
When?
When was the last time you recall talking to Demekion Garlington?
I'd probably say 2022.
Okay. Did you ever talk to Kenneth Copeland or Demekion Garlington, either of them, about a RICO indictment?
You said, did I ever talk to them about it?
Yes, sir.
I don't remember. So if you have anything, you can refresh my memory. Yeah.
Do you have any memory of having conversations about a potential RICO indictment before this indictment or its predecessor was ever brought forward?
I don't remember, Ms. Love. I'm being honest with you. I don't remember.
Thank you. I appreciate that. Your Honor, at this time, the state asks permission to publish 442 Yankee. I'm sorry. We tender 442 Yankee as evidence.
All right, that is admitted and you may publish.
Thank you, Judge.
All right, we're on the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, Councils Love and Hilton. Okay, Councils, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right, Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you should give in the matter now in hearing should be the truth, the whole truth, nothing but the truth, so be God or so firm?
Yes, I do.
All right, you put your hand down, sir.
Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Moontum, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influence and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney
Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing. We might need to skip forward 2 seconds.
I was sure like, what the hell going on? Thought I was tripping, yo.
The agreement is not captured. I'm going to object to skipping forward. I'll see.
Let's see.
Your Honor,
I'm not saying to skip anything substantially. I'm trying to
Right.
see if they can skip over the part where it's just repeating
skipping,
itself.
yes. We're sharing through a different screen and we're going to go ahead and pick up
On
at
these
6:40
charges.
At 6:40 where we stopped.
It has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3 special conditions of sentence of this plea agreement. The state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual
I'm convinced they just trying to pass time on this Friday, you guys. Today is September the 6th, Friday. That would make day 124 of the Young Thug YSL trial. You guys, they have Antonio Sledge back on the stand again, and now she's going through some court proceedings that he had in the past. They just trying to push stuff along. Today, Friday, it's the weekend, y'all.
acknowledgments are as follows. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffery Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. The defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word, B-E-G-I-N to B-E-I-N-G.
Then initial right there.
And Mr. Sledge, is that your initial above the strike through of the word began to change it to being?
Yes, ma'am.
Okay. And may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgements?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgements, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you signed your name underneath?
Yes, ma'am.
Your Honor, the state tenders as evidence, State's Exhibit 1AS.
Any objection? States 1AS is admitted for purpose of plea.
Mr. Sledge, I'm showing you, and Your Honor, I'll show defense before I present it to him, what was admitted during that session as 1AS. If anyone wants to see it, if not, I'll go ahead and approach the witness. All right. Mr. Sledge, would you please take a look at 1AS and tell me if 1AS, which was admitted for the purposes of your plea, and the document we have been referring to, yes, thank you, as states 444 Yankee, and I will now add back the first 2 sheets. Would you please look at those 2 documents and tell me if states 444 Yankee is an exact copy of States Exhibit 1AS that you signed on December 28th, 2022.
Look at the whole thing, or just the
Yes,
right,
sir. Please look at the entire thing.
Yes, I remember this one.
And is States Exhibit 444 Yankee an exact duplicate of the document labeled States Exhibit 1AS?
Yes.
All right. Thank you, Your Honor. One moment.
All right, is there a cross-examination of Mr. Sludge? All right, go ahead, Mr. Sharp. Yes.
Mr. Kokomo's in need of the Zoom link.
It's the same it's been all week. Can you look at maybe a prior day's email? Or the state will forward it. Thank you. He's got it. He's in.
Mr. Sledge, good morning.
Good morning.
My name is Max Sharp. I represent Shannon Stillwell, okay?
Yes.
All right. I'm going to be asking you some questions about that document that you were just reviewing. Do you have that up there with you?
No, she took it.
Okay. If I ask you specific questions about that document, do you think it might be helpful for you to have it in front of you to refresh your recollection?
Yes.
Okay. Your Honor, ma'am.
Yeah, I think it's right up with the court order.
Okay.
Oh, okay.
I'm not.
Okay.
We'll get there.
Okay.
And just please listen to my questions and answer truthfully, okay?
Yes.
All right. Ms. Slade, I'm going to ask you to go back to December 28th of 2022, okay?
Yes.
Now, that is the day that you pled guilty, correct?
Yes.
And that's also the day, as I understand it, that you initialed that document. Is that correct?
Yes.
Initialed the actual acknowledgments within the document, correct?
Yes.
All right. Let me ask you one question before I get there, though. What day were you arrested on this case?
I want to say May 27, 2022.
May 27th, 2022. Well, that works out well for my limited math here. Okay. So, May 27th of 2022 to December 28th of 2022. That seems to be 7 months. Is that correct?
Yes, 7 or 8.
Okay. So on December 28th, 2022, when you initialed those documents, you had been locked up for 7 months.
Yes.
Okay. You had previously moved for a bond in this case, correct?
Yes.
You moved for a bond on October 13th, I believe, 2022.
I don't remember the date, but yes, I know.
It was in October?
Yes.
And the state opposed your release on bond, correct?
Yes. Yes.
And Judge Glanville denied bond, correct?
Yes.
Okay. So on December 28th, 2022, you had been locked up for 7 months and 1 day, and you did not have a bond.
Sustained.
On December 28th, 2022, you did not have a bond, correct?
Sustained.
Let me ask you, when you were locked up, or say locked up, where were you living? Where were you held?
At Forest County Rice Street.
Okay. That's Fulton County Jail?
Yeah, jail.
Okay, we're not
Generally speaking, is that a nice place to be?
Everrule.
No.
Is that a dangerous place?
Yes.
Is that a filthy place?
Yes.
Okay. On December 28th, 2022, there were some things going on in your life, correct?
Yes.
Okay. You've already shared with us that your mother was ill.
Yes.
Certainly, on that date, you wanted to get home to your ill mother. Isn't that correct?
Yes.
You are also a father, right, Mr. Sledge?
Yes.
You have 8 children, is that correct?
Yes.
Okay. On December 28th, 2022, I don't need to know the age of every child, but what was the age ranges?
23. The youngest 9.
The youngest was 9.
She's 9 now.
Okay, so about 7.
Yeah, about 7.
And do your children live in Atlanta?
Yes, all of them.
Okay, do you spend time with your children?
Yes.
Sustained.
Do you attend to your children's daily needs?
Sustained.
Your Honor, may be heard.
You may.
It goes to his need to get out of jail.
All right, we'll get to it.
Okay, do you attend to your children's daily needs?
Yes.
Do you drive your children to school?
Let's move along a little bit.
Okay. Did you have a significant other at the time?
Yes.
Everrule.
Yes.
And I don't even need to say her name, her initials are DB.
Yes.
Okay. On December 28th, 2022, did you miss DB?
Yes.
Did you miss your children?
Yes.
You indicated that Derek Wright is your attorney,
Yes.
and he's represented you in the past.
Yes. Yes.
And you hired him on this case.
Yes.
When you testified, I want to make sure I'm correct on this, you paid him a certain amount of money, and I don't need to know the amount. He's testified that he did not, his understanding was he did not pay his attorney. You didn't, the money that you paid your attorney, you knew it wasn't enough for him to go to trial on this long case, correct?
Yes.
That was your understanding.
Yes.
That was his understanding.
Yes.
You did not have an attorney to take this case to
All
trial.
right, no. Now, we all know that that's not true. That anybody who can't afford an attorney is entitled to get an attorney without cost to them.
I'm going to get there. There were people in this case that couldn't afford an attorney, correct? People were, people still don't have
Hey,
attorneys.
hang on. Don't talk over each other. That is not relevant to the question that you're asking him, nor to this trial going on right now.
Your Honor, may I be heard?
Yes,
If he knows he's going to
you
sit,
may, yes. You know what? Let's break for lunch, because I know that this is going to take more than 30 minutes for you to do your cross, so let's just break for lunch right now. Huh? Time? Oh, right, well, I've got some, we have to deal with some other matters. Let's say 1:30. Isa. Let's take up this objection.
so Your Honor, and I say this not in a pointed fashion, you weren't here in the beginning of case.
Yeah.
And I know that you're not presiding on the case with the other individuals. The reality is, people were severed off this case because our public defender system did not provide people attorneys. People were sitting in jail for up to 2 years. I'm not even sure everyone has an attorney to this date. These gentlemen that are not sitting here, that are sitting in 901 Wright Street, 2 years later, I don't even know if they have attorneys now, but I do know when we started this trial, people were severed because the public defender system had not provided attorneys. Mr. Sledge knew that. Mr. Sledge, and this is the reality, and I don't think we should hide it from the jurors. The reality is Mr. Sledge had two options: plead guilty or wait for an appointed attorney to try this case, and he would have been sitting in jail, and he'd still be in jail today.
All right, all of those cases are ready to be tried right now. Everybody who's been severed out other than for that reason is ready. And
well, right, and they're still in jail.
Well, so are all of these defendants.
Well,
so we're not going to get into that, are we?
Well, at this point, I really probably wouldn't mind, but I'm not going to speak for everyone else.